Good morning, good afternoon, and good evening, ladies and gentlemen. Welcome to KCAB International and Friends webinar. Today's webinar is the 9th one, titled Playbook, Managing Arbitrations Involving the Middle East and North Africa, together with Tamimi, the leading law firm in the MENA region. Today's webinar is the last one of this year since we've started in April. We, KCAB International, truly appreciate your participation, even your tight schedule, and hope this webinar series have been helpful to you, to all of you, for overcoming this tough season due to COVID-19. Without further ado, I would like to invite Professor Hi-Taek Shin, Chairman of KCAB International, to deliver his welcome remarks. Professor Shin, please.
Good afternoon, ladies and gentlemen. It is my great pleasure to welcome all of you to the 9th KCAB International and Friends webinar series today. I would also like to extend my sincere appreciation to our dear friends at Tamimi and Company for co-hosting this webinar. As you may know, Tamimi is the leading full-service commercial law firm in MENA region with 17 offices across 9 countries. It has a Korean desk. Special thanks are owed to Messrs. Thomas Snider, Ji-won Ha, Philip Kotsis, James Harbridge, and Hani Naddaf for sharing an expertise and experience on various aspects of managing arbitration involving the Middle East and North Africa, so-called MENA region, with us today. Korean companies have been very active in the infrastructure projects in the Middle East since late 1970s and have contributed to the miracle of the desert. I recall that in my earlier years as a young lawyer at Kim Chang in early 1980s, I worked almost every day on the financing agreements supporting Korean construction companies for their projects in Middle East. I am sure that the partnership between Korean businesses and the countries in Middle East and North Africa will continue to expand in the coming years. Expansion of business transactions naturally has led to an increase of disputes. Mega-sized infrastructure construction projects tend to generate a substantial number of complex disputes. Different culture and different business practices, as well as different perspective in resolving dispute resolution, add to the difficulties faced by Korean businesses in MENA region. As a result, we have seen significant number of international arbitration cases involving Korean companies arising from their projects in MENA region. In the past, quite a number of those international arbitration cases was seated in European cities such as London, Paris, or Geneva, and typically administered by LCIA or ICC. However, as countries in the Middle East in recent years have made remarkable progress to modernize its legal system and offered a very efficient and effective system for the resolution of international disputes, we now see a trend that disputes arising from MENA region is being resolved in MENA region in several of those jurisdictions. We also see an encouraging development that some of those disputes involving Korean parties, in particular, those disputes between Korean contractors and their subcontractors are coming to KCAB International. In view of this development, it is crucial for Korean businesses doing business in MENA region to understand the arbitration environment prevalent in the MENA region, such as what the arbitration laws and rules are in this region, and how these laws and rules are implemented in practice, and whether there are important differences from those of other jurisdictions familiar to Korean businesses. Today's webinar will give you a great opportunity to learn those topics from the prominent regional arbitration practitioners at Tamimi. They will share their experience in international arbitration in the MENA region, some of which involved Korean parties. You will get practical tips for the use of arbitration and how to avoid pitfalls when pursuing arbitration in the MENA region. For those of you who are interested in learning about arbitration practices in the MENA region, I am sure that this webinar will be very informative and rewarding. This webinar marks the last event of this year's KCAB and Friends webinar series. We will continue to offer this webinar series next year with informative and useful contents on a variety of issues in international arbitration practice. I wish a happy new year to everyone and hope that you stay safe and healthy until we meet again next year. As United Kingdom started vaccination yesterday, I am hopeful that we will soon be out of the long and dark tunnel. Thank you again for your participation today.
Thank you, Professor Shin. Next, I would like to introduce one of my best friends at Tamimi and Company, Mr. Ji-won Ha. Jae, could you be the owner of Mr. Ha, handsome gentleman? Mr. Ha is a senior counsel of Tamimi and Company's corporate commercial department, and then leading the firm's Korean group with his over 15 years of specialized experience of complex cross-border transactions, including public and private M&A, project finance, and strategic investment. Actually, I have a few more pages to describe Mr. Ha's capability and ability, but however, without further ado, I will just invite Mr. Ha. Mr. Ha, are you ready?
Yes, thank you very much, Director Kwon and KCAB International. 안녕하세요. 알타이미 하지원 변호사입니다. Hello everyone, thank you all very much for joining us today. As Director Kwon kindly introduced me, I'm a senior counsel at Tamimi and Company, heading up the Korea practice group here in Dubai, UAE. I am very delighted to be co-hosting this 9th session and the very last session of this year's KCAB International and Friends webinar series. And it is my pleasure to welcome you all on behalf of my team. We have 4 speakers today, all from our own Tamimi offices. I will not read their long bios, but wanted to just highlight their unique career and experience of each speaker. First, Mr. Philip Kotsis. He is a partner and co-head of our Kuwait office. Mr. Kotsis is a US qualified lawyer with an extensive experience in corporate transactions and M&A in Kuwait. He has been advising on corporate and finance aspects of almost all the major Kuwait infrastructure projects and PPP projects, including water desalination, power generation, and wastewater treatment plants. Recently, he advised a Korean law firm on Kuwaiti law aspects of distributorship issues in one of KCAB arbitration cases. Next speaker would be Mr. James Harbridge. He recently joined Tamimi as a partner and head of dispute resolution in our Oman office. His particular expertise falls in construction arbitration and the Oman market. He actually spent 16 plus years working in Oman. James is ranked as a leading dispute lawyer by many legal directories like Chambers Partners and the Legal 500. Our third speaker is Mr. Hani Naddaf. Mr. Naddaf is a partner and leading the whole disputes team in our Doha office in Qatar. He is a dual national of Syria and Canada, so fluent in both civil and common law. And he has been involved in various high-profile construction litigation matters and many of the most high-profile projects in Qatar. He is a hot pursuit by all the major global players, contractors, and international firms to act as either lead counsel or local counsel in relation to large-scale commercial and construction disputes governed by Qatari law. Last but not the least, our fourth speaker is Mr. Thomas Snider, our head of arbitration based in Dubai. He is a very experienced arbitration practitioner in international arbitration scene. He's a Harvard Law graduate and has a very unique career as an arbitrator. From 2001 to 2009, Tom was a member of the legal team representing the Ethiopian government before the Arbitration Tribunal adjudicated claims arising during international armed conflict. So in that context, he worked as a resident attorney in Addis Ababa for 3 years. Now he is frequently invited to speak on many topics involving arbitrations in the MENA region, and he's also a member of CIAB and KCAB International. Now, I'm going to turn it over to my colleague, Mr. Philip Kotsis, to start the first session. Philip, can you please take the floor?
Yes. Hello, everybody. Can you hear me? Can everybody hear me okay?
Yes, I can hear you.
Okay. Let me just get these slides. Excellent. All right, thank you, everybody. It's a pleasure to be with you all today and with the Korean Commercial Arbitration Board. As Juan said, my name is Philip Kotsis. I am a partner in the co-head of office in Kuwait, and I've been operating in the GCC and Middle East region for about 11 years now. And I have a broad range of experience in terms of my legal background. I cannot say that I have been a lifelong arbitrator, but I think the input that I have for you today is important because it shows the relationship that different law firms have with the Middle East and with our group in particular in terms of carrying out arbitration matters, where you have our expert arbitrators such as Thomas, who's going to talk to you later on, and then you have people who are used in arbitrations based on the expertise. And so that's what I'm going to kind of get at today from a general point of view. So the couple things that we're going to be going over today in my brief time that I have is the relationship between international law firms and local counsel in the Middle East. We'll talk about arbitration versus litigation and the role of local counsel and being proactive and the benefit of reaching out to local counsel early. And I think this applies in two different ways. One, if you're with Korean law firms that are doing, or Korean businesses that are doing work in the Middle East, and also disputes that arise in the Middle East involving Korean companies that are taking place, you know, in Korea, as I participated in earlier this year. So it applies both ways, and I think that's what's important. And so when we're talking about the relationship between international law firms and local counsel in the Middle East, it's important to understand that your reach of what you're looking to, the global reach that you're looking for is extremely important. And not to just self-promote our law firm, Tamimi, but the reach and expanse that we have within the Middle East is extremely important because it does show that we are able to handle matters very differently than other law firms. So for example, if you're a company and you're looking to do a arbitration matter or have a dispute in the Middle East, or you have a Korean company working in the Middle East that may be arbitrating in Korea or elsewhere in the world, it's important to understand where that local place, where the dispute is arised from. In other words, there's a number of jurisdictions in the Middle East. They're not all the same, and that's critical. So, for example, Tamimi Company has offices in Bahrain, Egypt, Iraq, Jordan, Kuwait, Oman, Qatar, Saudi Arabia, and the United Arab Emirates. And within those countries, some of them have multiple cities. And that's important because if you have a dispute in the Middle East, it doesn't mean the Middle East just has a general, civil law system that everyone follows. It's important to know the nuances of each law, whether it's in the United Arab Emirates, whether it's in Kuwait, whether it's in Jordan and Egypt, and that's extremely important. In addition to that, using local law firms is very important because you have to look at the specific sectors that they're participating in. So, for example, our law firm, Tamimi Company, has a vast array, I should say, of specialist experts, lawyers, and legal practitioners within its firm. So we are not just a generalist firm where you go to a certain jurisdiction and say, I hope we have a lawyer that can tell us about, Omani law or about Qatari law or Kuwaiti law. We have arbitration professionals, banking, construction, corporate, commercial, private clients, real estate, litigation. If you know the role that you're playing or the specifics of the arbitration you're in, you can get the counsel that plays that role for you. And that's extremely important to know that there's specialists in these countries that know the ins and outs of each of the laws and practices of these jurisdictions so that you can have a successful arbitration for your client. And that's extremely important. So when we talk about the relationship between the international counsel and local counsel in the Middle East, as I said, we maintain strong ties and relationships with a number of international law firms throughout the globe, which means we work with companies all the time, other law firms, whether it's in the Far East, whether it's in North America, Europe, Africa, South America. We maintain these relationships with law firms so that we can participate with them when disputes arise. A strong relationship between international counsel and local counsel is extremely important to provide the client with the best services possible. So that relationship, that connection between the international counsel, when I say international counsel, I'm talking about counsel outside of the Middle East for purposes of my discussion. That relationship is extremely important. So you have a good exchange and a good knowledge of what needs to be done in terms of preparing for and carrying out arbitrations, whether they're done in the Middle East or whether they're done, outside. Our particular platform allows international counsel to benefit from legal practitioners and specialists throughout the Middle East. Like I said, we have numerous specialists. We're not a generalist firm. So if you need someone that's an expert in real estate in UAE, we have it. If you need an expert on someone on agency distributorship in Kuwait, we have it. And that's what's very important so that you can get the best services and nail down each particular issue in any particular dispute. Close working relationship between international and local counsel is critical to the arbitration process. And I'm going to go through my recent experience very quickly with Shin and Kim in a KCAB arbitration matter that we had earlier this year. And I'm not going to get you into the details of it, but just about the working relationship. So it involved a Kuwait law issue regarding the registration of a agency agreement in Kuwait. It was Korean law based. It was a KCAB arbitration matter. And we had 3 arbitrators that dealt with this foreign principle that was based out of Korea and a local Kuwaiti agent in relation to a distribution contract. So the relationship with Shin and Kim was very important between Tamimi and Shin and Kim to make sure that all the issues were known and applied in the dispute. So they had to learn a lot about Kuwait law. We had to learn a lot about Korean law and where they blend and where they do not, cross paths. And that's very important so that we can provide our arguments both on a procedural and substantive matter. So we work together to formulate our submissions. So they would prepare something, we would look at it, we would prepare something, they would look at it. So we would submit together to make sure that both from a Korean law standpoint and from a Kuwait law standpoint, we nailed down all the issues. There were no language barriers, as we have English speakers in the Middle East, and they had English speakers in Korea, and that was the language of the arbitration. So we had Arabic-speaking clients, Korean-speaking clients, and English-speaking lawyers. We had everybody was involved. We were able to communicate very efficiently throughout the arbitration process. And it's a winning combination based upon the ability of us to communicate, to know the issues, and to work closely together with Shin and Kim. We were able to put together a successful arbitration and had a great outcome for our client. So it's very important to build these relationships between the international firms and the local firms carrying out these types of matters. In arbitration versus litigation, I don't have to explain, obviously from a basic point of view, the differences. But it's very important when you talk about, knowing your law firms in the Middle East, because there will always be attempt, or many times there'll be an attempt by local parties in the Middle East to resort to litigation as opposed to arbitration, because they want to get the benefit of local court, or the perceived benefit. But in arbitration, cases may turn on local law principles. So that's why it's important to get involved with your local counsel very quickly. There's a dynamic between the host country application of law and procedure and local legal analysis. So you have to work that dynamic between how we're applying the local, let's say it's in Korea, the arbitrations with KCAB in Korea. How does the local procedure rules blend with the application of procedural or substantive law from the Middle East jurisdiction? Local legal practitioners can provide significant contributions to legal discussions. Obviously, the arbitrations are generally less formalistic than litigation matters. Arabic is not required, so it allows foreign law firms to be involved in matters that in litigation you're going to have to use Arabic. Understanding local law, even where it's not necessarily required, is important as well. For example, at the outset of the Shin and Kim, when we worked with Shin and Kim on the arbitration this summer, it was thought that only Korean law would apply. But as it turned, as the case started moving forward, we learned that Kuwait law could apply, and at one point the arbitrators wanted to know both laws in determining which law would apply, and if they did apply Kuwait law, how would it be resolved, and if they did apply Korean law, how would it be resolved? So that was very important. And on the litigation side, it's much more formalistic. Like, for example, in Kuwait, you have to follow Kuwait law and procedure to the T. Arabic language is used. There's no English, so the international counsel plays a much smaller role in those type of matters, other than feeding back information. The client help formulate strategy, but can't really participate in the actual litigation process. You see a frustration with local courts sometimes, as opposed to arbitration matters. You have to apply. The application of foreign laws can be difficult. If you have an agreement that says we're going to apply Korean law, for example, in a Kuwait case, you may have some difficulty in getting the courts to apply that law. And of course, enforcement of judgments in whether they're foreign judgments coming into the Middle East or Middle East judgments going out to foreign countries can always prove difficult. And finally, being proactive. And I think this is very important. And reaching out to local counsel early in the process is critical to the entire process. When possible, international counsel should work with local counsel at the contract negotiation phase to ensure that arbitration is possible. It's very important. Obviously, you can't always do that. You're not involved sometimes in the contract drafting or negotiation phases. You get it later on when you receive a client that has a dispute. Of course, you can't be that proactive at that stage, but if possible, and you want to use arbitration, get involved early with your clients in terms of the contract negotiation, because you need to make sure certain things. Now, I'm talking very particular with Kuwait, because that's where I've been for a very long time. And this may change from jurisdiction to jurisdiction, but you look at things like, are your countries signatories to the New York Convention? What does your arbitration clause say? And are there any local law hurdles, authority and capacity to enter into an arbitration clause? Is litigation an option? Are you making it optional in the agreement? And how will that affect your arbitration clause? So a lot of things will impact whether you're able to go through an arbitration process. That's why it's very important to get involved with local counsel and get their local counsel views on these things right at the beginning. Sometimes you can contest local jurisdiction where there's an arbitration clause present. For example, in Kuwait, if you have a valid arbitration clause, yet the Kuwaiti party decides to start litigation, right at the outset, you have to argue that there's a lack of jurisdiction due to arbitration. If you do not, and you wait till later, you can waive that. So that's extremely important that your clients know, and that you have that relationship with local counsel so they can advise on how to approach a situation where there's an arbitration clause, but there's a party seeking to litigate. You work with local counsel to formulate the arbitration case, the claims, the defenses, and strategy. Start it from the beginning, and that way you know from beginning to end exactly what you need to do, and we can educate the international counsel on exactly what needs to be done or needs to be argued from a local law perspective, and what needs to be done from a procedural perspective if the procedures apply. And you just have to decide also, will local law apply? Again, starting out early, being proactive is extremely important to make sure this gets done, because it causes less stress later on in the process if it's determined that, it looks like we're going to have to apply Qatari law or Saudi law or Kuwaiti law, and it's months and months into the arbitration process. And finally, don't underestimate the impact of local practitioners chosen to appear and argue before the tribunal. Now, I'm a little biased when I say this one because I believe that there's no better firm to reach out to than Tamimi and company in terms of our expertise in arbitration and general law matters, no matter what the sector with throughout the Middle East. However, it's important to not underestimate the impact of these individuals, because we have been involved in arbitration matters where other local counsel have not appeared strong, have not appeared to have the language capacity to argue a case in English properly, and have not chosen arguments in the correct way or not progressed their arguments in the proper way before the tribunal. And we've taken advantage of those situations. So involving local counsel and the actual local counsel you choose is very important. And again, it's a little bit of shameless promotion here, but because of the expertise we have, because of the specialists we have, Tamimi is probably best suited, it is best suited to serve out these needs for international counsel that need assistance in the Middle East. So I think I'm out of time, but thank you for giving me the time to briefly discuss these issues with you. Over to you, Juwan.
Okay, thank you, Philip. Just I had a very nice had a nice opportunity to have a wonderful just lesson your practice in Kuwait. Then, as scheduled, just I would like to invite James Harbridge. James, are you ready?
Yes, absolutely. I hope you can hear me. Okay. Thank you so much. I'm just going to spend a few minutes talking about the Omani arbitration law. This is a jurisdiction I know very well because I came to it and have worked predominantly with Omani law since moving to the Middle East in 1999. So it seems a long time now. So I just wanted to start off with a couple of generic comments. The interesting thing about Omani law is there is no concept of witness statements. So if you look at the Omani court system, it began as recently as 1984. And even now, apart from some select labor cases and criminal cases, it is extremely rare for the Omani judges to ever seek witness testimony, and certainly Omani court litigation progresses without any witness statements ever being filed. And the reason for this is because Omani law puts a huge emphasis on contemporaneous records. And that's something I wanted to flag at the beginning. A colleague of mine and myself saw a situation where a construction client had maintained a very poor document management system. And we saw that they'd been advised by a previous law firm, in a few weeks earlier, that they would need to update everything into a sophisticated document management software, and it would cost them about $100,000 or $150,000. So I know I'm speaking to a sophisticated audience. You all know the importance and significance of maintaining records, but it's particularly true in Oman, where the focus is always on the contemporaneous primary records. So everything has to be collated and kept very smoothly, daily, weekly, monthly progress reports. Often they're not available, we find, but those are the things, of course, that arbitrators and experts require, as we know. Another second quick generic point I wanted to make is obviously legal spend, especially at the moment, is extremely critical for everyone, and everyone at Tamimi appreciates the sensitivities and pressures in this respect. We are open, obviously, to looking at alternatives to hourly rate. And the only point I'd make here is the more we know about the dispute, the more possible it is for us to come up with some innovative type of fee structure. So often you will hear lawyers say, well, we would love to show some accommodation on fee structure, but it's too early for us to know because we need to see more. I think the more we know, as I say, the more we can assist you. And obviously when setting a budget, as you all know, there's so many elements that we need to consider apart from lawyers. You've got your experts, your arbitration fees, maybe the cost of barristers, e-bundling, virtual platform at the current time, transcribers, printing, and also the things that often get forgotten are the ultimate cost of enforcement. I should say Oman is a signatory to the New York Convention, but it is worth looking at the issue of enforcement and how that would occur and where, right from the outset before you even start the arbitration. And equally, one should be aware, and I'll come back to this point, that there are potential nullity proceedings, or once you get an Omani arbitration award, there are two levels of appeal or attempt to nullify can be made in the appeal court of Oman. And if that fails, there's a final tier of justice, the Supreme Court, that will hear a nullity application, but I'll come back to that. So just before I talk about the issue of notices, the Omani arbitration law was issued in 1997. It provides for ad hoc arbitration. It is not aligned with any arbitration center. Now, an issue that many people don't understand, even often the practitioners themselves, is that there's an Article 27 of the Omani arbitration law, which says that the arbitration starts on the day the defendant or respondent receives the notice of arbitration, unless the parties agree a later date. And the importance of this is it interacts with Article 45 of the Omani arbitration law, which says that you only have 18 months from the start date for the arbitration award to be rendered. That's a sort of drop dead date unless both parties consent in writing in advance to a later explicit end date. So a common mistake that's often made by a claimant is to serve a notice of arbitration too early, because the 18-month clock begins to tick as soon as you put in that notice of arbitration. And ideally, if a contractual scenario allows it, the ideal would be to serve your notice of arbitration once you have your statement of claim ready. Now, it's interesting that you can obviously have an Omani dispute, which is, say, governed by ICC rules, and then you get a tension between the rules of the ICC and the likely duration of an ICC arbitration, and how that can clash with the Omani arbitration law, which, as I say, has this prima facie 18-month duration. And we've seen a situation before where the tribunal said, well, the ICC rules just supersede the Omani arbitration law. But the ICC Secretariat overruled that, and I think rightly said, even if the ICC rules have been agreed to by the parties, to ensure the ability to enforce the final award, the Omani arbitration law must not be contradicted, and the ICC award had to be rendered within the 18-month deadline set by the Omani arbitration law. Just a few quick points whilst I'm still on this slide. I know time is short, so I'll be quick. In terms of method of service of a notice of arbitration, if a contract is silent, this should be served either by hand and or by courier. Three other points I'll quickly make here is there's no agreement on the number of arbitrators, then it will be a panel of 3. On language, the default is Arabic language unless the parties agree otherwise. And also an arbitration will proceed, and if either party thinks there is a procedural irregularity, they must raise an objection within 60 days of becoming aware of that alleged irregularity. Otherwise, they lose the right to object to it later. I'll go to the next slide now and quickly talk about experts, as I know you are all a sophisticated audience. Obviously, experts should be appointed as early as possible. Choosing the right expert is vital. Often we see people want to go with the cheapest option, and that can often be a mistake because certainly in construction arbitration, a lot of cases are won and lost on the quality and diligence of the expert. So it can be very much a full saving to simply go for the cheapest option. And also getting a wrong expert can also increase the amount of work the lawyers have to do and maybe the barristers as well. And so a saving with the wrong expert might lead to a lot of additional work for the lawyers. And then it goes without saying, in terms of choosing arbitrators, it's important to think what your case is, what the other side's line of defense or argument will be, what type of arbitrator do you really want with what type of experience, because often we see in an Omani arbitration context, we see Western arbitrators, maybe from Switzerland, Germany, France, England, who actually are not that keen to look at the Omani law provisions, the Omani court judgments, who don't really understand the customs and practice of maybe the Omani construction industry. It's important to know that many contractors in Oman will say that if we raise issues too early on, we'll be told we won't get additional projects. You need to have that wider knowledge of the customs and the practice, as we all know, to really understand why a dispute has arisen in the way that it has. So the Omani arbitration law, I'll go to the next slide, is just a simple 27-page document, but it works, and it has worked for over 20 years. Article 33 is interesting because it says disputes can be decided on the papers. There's only an in-person substantive hearing if both parties agree to that in writing. Also, Article 36 allows the tribunal to appoint its own experts. And so traditionally in Oman, we had very simple procedural timetables. Often there would be 2 submissions each. Then the tribunal would appoint an expert. The expert would do a report. The parties would provide written comments on the report. And then there'd be a session to maybe cross-examine the expert, and the parties would bring their own experts to state their opinion on the issues. Increasingly, with Western lawyers moving into Oman, I've seen a big change in '99. And so what has happened is that the procedure has elongated a lot. So we get now disclosure and opening submissions and closing submissions, and it's not always the way you want the case to be, quite frankly. So in closing, I just wanted to very quickly mention the issue of nullity again. It's important, as I say, that there is a catch-all phrase in the Omani arbitration law that says a party can apply to nullify, quotes, if there is nullity in the arbitration judgment, close quotes. And so it is now the norm for all Omani arbitration awards to be the subject of a nullity attempt via the Omani courts by whomever is the losing party. I hope that gives you a quick introduction to the Omani arbitration law. Thank you very much for your patience and time. And I now turn the floor to Mr. Hani, and I hope he's there for us. Thank you very much for your time, as I say.
Hi, everybody. This is Hani and Naddaf. I am a partner, the head of dispute resolution in Tamimi, Qatar office. And when I was asked to present a topic to the audience from Korea, especially about arbitration related to Qatar, I thought immediately to speak about the JV in general, because actually this is the main common way to get a big contract with the government projects. So as some of you may know that all the projects, the big projects in Qatar recently has been conducted by JV. Even the government of Qatar imposed that the main contractors must be a JV of companies, usually including the high level and sophisticated contractor, in addition to a local company. So in Qatar, it's very common to have a JV performing the big projects such as the stadiums. All the stadiums in Qatar are, the main contractors are big JVs, and the metro project as well, and the infrastructure. So you would know that what the benefit this, apart from the fact that this is imposed or required by the government, there are many benefits, as you can see. The cost will be shared, the liability will be shared, and you don't have to set a company in the jurisdiction in Qatar, and hence you avoid the cost. So we have the JV, and we signed the contract between the JV from one side and the employer from other side. Now, what does the JV company say? It is usually it's contained. It contained the many terms and provisions, such as, for you can see, it is first it's important, and this is why I wanted to raise this to speak about the JV. The main issue that all the JVs in Qatar, not all, most of them, they have difficulty to understand is the structure, the legal structure of the JV. The most important element or characteristic of the JV is that it is a hidden company. So it is unincorporated in the sense that it's not public. There is no commercial register. It doesn't constitute a separate legal personality. You may know that under civil code, the concept of legal personality, it's very important and has many important legal consequences. I will come to it later on. So this company is not registered. The JV is not registered, doesn't have CR, separate CR, doesn't have commercial license. It is an unincorporated hidden company, and it doesn't have separate legal personality from the member of the JV. So this is very important. I will come to the importance of this later. So, and again, it's very important point for the JV members to understand that there is a big difference and important distinction between the JV agreement and the underlying contract with the employer. So these are totally separate agreements, and whatever inside the JV agreement doesn't affect the relationship with the employer and with third parties. like for example, subcontractor. However, the JV agreement still, it's a very, very important document, but it governs only the relationship between the JV members. Whatever there is, there are provisions inside the JV agreement do not apply, do not affect the relation with the employer, as I said. So in the JV agreement, it's Article 54 of the Commercial Companies Law gives some indication what you need to insert, but this is not exclusive list. You can just add whatever it is important to the members, but obviously you have to determine the objective, the right and obligation, the distribution of profit, who had how the company is managed, the board or the board of director. And so this document is very important to govern the relationship between the JV members. However, when it comes to third parties, when there is a dispute or there is arbitration or litigation case involving the JV, then we will have now we have to distinguish what will be the liability of the JV members vis-a-vis third parties. And this is a very important question. Usually under, as you can see, Article 57 of the Commercial Companies Law, it said that if a party of the JV act in his behalf, not on behalf of the JV, then the third party will have recourse against this particular member only. This is very, very uncommon, and I have seen it like 1 or 2 times when the JV members enter into a contract with third party separately, not in the name of the JV. What is much more common is that the JV, all the JV members are jointly liable vis-a-vis the third parties. And this joint liability includes the responsibility for performing the work and the liability on the any debts or any financial compensation or damages that the third party may have against the JV. So this is very important. What does joint liability mean? Joint liability in the construction in the any arbitration under Qatari law mean that each member of the JV will be liable for the full amount of the debt related to the JV. So the third party had the right, the employer, in the arbitration process, has the right to file a case against one member only, but he can claim the full amount. If there is like LDs, if there is any other compensation, any other claims, the employer or the subcontractor may have against the JV, they have in principle the right to file a case against one member or against all the members of the JV. And once there is an award or judgment against the JV, the other party has the right to enforce the judgment against one of the JV members, notwithstanding the share and participation under the JV agreement. So if the JV agreement says 60, 30, 10%, but the third parties do not care about this split. They have the right to go after the JV members all, or they can enforce the judgment against one of the members with the full amount. And this is very important. This is the consequences of the joint liability, and the consequences of the fact that this company doesn't have separate legal entity. So this is a joint liability. And however, the JV agreement will come into play if one party pays the claimed amount, one member of the JV paid the claimed amount in full. Now he will turn to the JV agreement to recover what he has paid in excess of his shares of his participation. So this is very important. I think it causes a lot of confusion in practice. Now, what is the capacity? Now, again, we have seen in practice many in arbitration cases. Actually, we have one of the cases on the basis of the capacity, whereby the claimant of the arbitration filed the case against one respondent calling JV XYZ. So the respondent Y is the JV, as opposed to first respondent X, second respondent Y, third respondent Z. So this is the right way to go. You cannot file a case against the JV as a JV because the JV doesn't have separate legal personality and hence doesn't have the right of audience as such. So the legal person which have the right of audience, the access of justice, and they have the right to be represented before the court and or the arbitration tribunal are the legal entities, which are the JV members, not the JV itself. The JV itself doesn't have. And if you want to file a case against the JV, you should file a case against the individual JV members, not against the JV. Otherwise, you will risk to get the case dismissed for jurisdictional reason. And this is good. It's very important to be aware of. Now, in the JV, as I said, the JV agreement, usually the JV agreement is entered into between foreign company and local company, as I mentioned. So the party can choose the governing law, which will govern the relationship between the JV partners. And this is again separate from the governing law under the underlying contract with the employer. So these are, as I said, two separate agreements. It is allowed to choose any law to govern the JV. The choice of foreign court, if there is any dispute arising out of the JV, to choose, like, for example, Korean court, this is a little bit risky because Qatari court consider that the jurisdiction of Qatari court is related to public order, and you cannot agree to go outside the Qatari court if the contract was supposed to be executed in Qatar. The third point is the choice of arbitration is always enforceable. So it is recommended that in any JV to insert arbitration clause to govern, to be to refer any dispute to the arbitration in case of any dispute between the JV partner. And again, under the contract between the JV and the employer or the subcontractor, again, this is the same rules apply. The agreement on the governing law, usually if the contract with the government, they will impose the Qatari law. Now, the choice between Qatari court and arbitration, again, it is always possible to go for arbitration if the contract is sophisticated and a big contract. So at this point, I would like to thank you for your attention. I hope you find this interesting and useful. And I will pass the floor to my colleague Thomas Snider. Thank you.
Thank you very much, Hani. And thank you to my friends at the KCAB for giving us this opportunity to take part today. It's good to see so many friends taking part as participants as well. I see names I recognize from Korea to Australia to Botswana and other parts of the globe. I have been assigned the daunting task of stepping slightly outside the Middle East region and covering the entire continent of Africa and its 54 jurisdictions in a matter of just 10 minutes and counting. A task that I think is made all the more difficult by the various developments that have taken place in relation to international arbitration in Africa over the past few years. But let me try my best to scratch the surface and give you a sense of what's been taking place on the African continent. I think when you step back and consider whether to arbitrate in Africa or what your options are, if, say, for example, you're a Korean company that is entering into an arbitration agreement with an African party, there are a lot of considerations that you need to take into account. But I think the four key ones are probably the same considerations that you will encounter just about anywhere on the globe. And that is, first of all, is the relevant jurisdiction where you're going to seat your arbitration a party to the New York Convention? If we were having this conversation just 2 or 3 years ago, I would tell you that you need to be very careful in this regard when it comes to Africa, because the rate of ratification of the New York Convention on the continent was not as high as it was in other parts of the globe. But just in a matter of 2 or 3 years, this has changed rather significantly. In the last 2 years alone, 6 or 7 African states have ratified the New York Convention. Ethiopia ratified it just this past August, and Sierra Leone ratified it last month. But of course, ratification of the New York Convention is not enough. The jurisdiction where you're going to seat your arbitration needs to have a robust national arbitration law. And I think when we look across the African continent, we do see some good indications of that. We have several jurisdictions, key jurisdictions, that have a national arbitration law based on the UNCITRAL model law, or at least an arbitration law that incorporates some of the key concepts and key principles of international arbitration. I mentioned Ethiopia a few minutes ago, which ratified the New York Convention a couple months ago. At this stage, I would still have some concerns about seating an arbitration in Ethiopia, since its arbitration law is a bit antiquated based on certain provisions from the 1930s in its Civil Procedures Code. Of course, the next sort of key issue is the arbitration ad hoc or institutional, and what is your institution? I'll be making some comments on this in just a few minutes, but I think we have a lot more options now in terms of arbitral institutions when it comes to Africa. And last but certainly not least, and one might even say the most important consideration is, are the courts in the jurisdiction where you're thinking about seating your arbitration friendly? And when you're talking about a land area the size of Africa, there is some diversity in terms of the reliability of the courts. We here at Tamimi, we've had some very positive experiences lately when it comes to courts in Africa. We recently represented the Middle Eastern subsidiary of a Korean company in a dispute with one of its distributors in Ghana. The Korean company initiated arbitration proceedings here in Dubai, in the DIFC, the Dubai International Financial Center to be specific. And then the counterparty immediately went off and filed court proceedings in Ghana. The counterparty was a Ghanaian party. We worked with local counsel in Ghana, and within just a matter of weeks, had a decision from the Ghanaian courts, very well reasoned, referring the Ghanaian party to arbitration consistent with its arbitration agreement. So we were very happy to see the reasoning and the speed with which that particular court responded to the situation. We had another experience recently, not with a Korean client, but another Asian client, a client based in Singapore, in terms of enforcing an arbitral award in Rwanda. And there again, I think the process was perhaps a little bit slower, but I think that was more indicative of our clients' desire to move things along quickly, and not so much any suggestion that the Rwandan courts were slow. You know, each jurisdiction is different. It's a big continent, but certainly in some of the key jurisdictions, we're seeing very positive support from the courts. I mentioned arbitral institutions a few minutes ago, and we are seeing African parties becoming more and more involved in arbitrations before many of the key international arbitral institutions. KCAB had multiple arbitrations with African parties from Senegal, Seychelles, and South Africa last year. In Singapore, the SIAC has as well. But I think traditionally we see a similar trend in Africa as to the one that Professor Shin referred to in his opening comments here in the Middle East, that there has, at least historically, traditionally, been a tendency of African parties for various reasons to use the ICC and the LCIA. And I think relatedly, historically, you've seen a lot of Africa-related disputes being resolved in seats outside the continent, seats like London and Paris and elsewhere. And if you look at the numbers even from 2019 from the ICC and the LCIA, that is indicative of this trend. But I think this is a trend that's changing. I think it's changing for multiple reasons. I think more and more parties and counsel and arbitrators in Africa are very rightfully and successfully making the point that Africa does have the legal infrastructure to resolve these disputes on the continent. And one of the phenomena that we're seeing in Africa over the past 5, 10, 15 years is a very large number of arbitral institutions sprouting up across the continent, probably dozens of them. I've listed some here in no particular order. That are probably some of the more active arbitral institutions in Africa. The one, of course, at the top of the list is the Cairo Regional Center for International Commercial Arbitration, which one might call the grandfather of arbitral institutions in Africa. It's been around since, I think, the late 1970s, has had a very active caseload, both in the Middle East region, the MENA region, and Africa more broadly. But we're also seeing a lot of activity in Kigali, Mauritius, Nairobi, multiple arbitral institutions in Nigeria, South Africa. One that I'm not as familiar with because I don't do much work in Francophone countries, but that is the Common Court of Justice and Arbitration, which is part of the OHADA framework. So if you're a Korean party looking to enter into an arbitration agreement with an African party, you do have many more choices than you used to have. Like I said, some of these disputes are going to Asia for resolution. They're going to London and Paris, and you have these options on the continent as well. One of the things that we're seeing here in Dubai, and I don't want to overstate this, but we are seeing an uptick in the number of African parties resolving their arbitrations, seating their arbitrations here in Dubai and in the UAE's free zones, particularly disputes between African parties and Asian parties. If you look at the map, I think the UAE and other countries in the Middle East make some sense in that regard. I'm running short on time here, but I want to make one point that I see come into play quite a bit. And I think probably for the participants in this call, this is already secondhand knowledge. But there seems to be a tendency when parties are negotiating an arbitration agreement that if you are going to have a particular arbitral institution resolve your dispute. So for example, I see this a lot here in Dubai. If the parties agree on the Dubai International Arbitration Center to resolve their dispute, there seems to be an understanding, and I would say a misunderstanding, that if you use the Dubai International Arbitration Center, that means you have to seat your arbitration in Dubai, and it also means you have to use UAE law as applied in Dubai as your governing law. I see this elsewhere as well. I think there's maybe a sense that if you use the LCIA, you have to seat it in London, you have to have English law. And as most of us, if not all of us on this call know, that's certainly not the case. You can have a arbitration administered by the Korean Commercial Arbitration Board that's seated in Lagos and applies Singaporean law, for example. And I just want to emphasize this point because I think this needs to be taken into consideration much more when parties are negotiating arbitration agreements. And I think it's something that Korean parties can keep in mind when they're negotiating with African parties, in particular parties from the Middle East. You might agree, for example, to have the Kigali International Arbitration Center administer your arbitration, but you're going to seat it in Seoul and apply Korean law. Or on the flip side, you're going to have KCAB administer your arbitration, but seat it in Nairobi and have it governed by English law, for example. So just sort of a tip to keep in mind. I think there's a tendency to sort of lump the arbitral institution, the seat, and the governing law together. So with that, I see my 10 minutes is already up, but I want to make one last point before I turn the floor back over. And I know this particular webinar is focused on commercial arbitration, but I just want to remind the participants to never forget about what bilateral investment treaties might apply in your project or your dispute. Korea has BITs with numerous African states. I have them listed out here on the slide. And you would be surprised how frequently, even if you have a contract in place with your counterparty who might be a state or state-owned entity, you may still have options for resolving any disputes under a relevant bilateral investment treaty. So keep those options in mind. There's various ways that this can come into play. Some of these bilateral investment treaties will define a public contract as an investment. So there may be ways of resolving a dispute with a state-owned entity under a bilateral investment treaty, even if there's a contract in place. And then you have umbrella clauses in many of these as well. So that's more of a reminder. Let me stop there and turn the floor back over to my colleagues from KCAB. Thank you very much.
Thank you so much for four speakers together with the Ji-won. Then we are just running out of time, but however, just we got some questions from floor. Well, even though we got just already just before starting. So as an MC, I would like to ask 3 questions for 5 speakers. And my first question is the delivery issue. Working at KCAB since 2002, one of the toughest issues that how to deliver in case of a relatively and small and medium-sized one. In mega case, in a huge cases, delivery issue, delivery or service is not an issue. But however, relatively small and medium-sized one, the respondent, not intentionally, but sometimes intentionally just wanted to reject to have a hard copy of request for arbitration or any substantial matter. So as Philip mentioned, as Hani or Philip mentioned, as James mentioned that, just Oman has a very specific just proceeding according to Oman Arbitration Act such as 18 months and commencement date. In case of KCAB International Arbitration rules, commencement date should be deemed as the receiving date of Secretariat after receiving the request for arbitration from claimant. So is fine either of you just answer my question. In case of delivery issue for hard copy, how clients deal with this matter in the MENA jurisdiction, including Africa?
I'm happy to jump in and start on this one. This is a recurring problem, and I think different jurisdictions deal with it differently. Here in the UAE, we had a new arbitration law come into force a couple years ago now, and I think that has provided an important tool to assist in this regard, because it provides that any written communication is deemed to have been received if it's sent to the last known mailing address. And a mailing address is defined to include either a facsimile, which might be old technology at this point, but more importantly, any email that was commonly used between the parties in their interaction. So the UAE has taken some steps to address this. I think it really is a question that varies jurisdiction by jurisdiction. Some arbitral institutions don't have rules that directly address this, and some, if not many, national arbitration laws do not either. So I think that's the best way to address it, either in the national law or in the rules of the institution. My colleagues might have some other experiences from the region.
Hi, this is James Harbridge. I could just add something from the Oman perspective. One interesting thing in Oman is that often parties contract with other parties without ever knowing the physical location address of their contractual counterparty. Now, obviously, that means when you're trying to serve something by courier, often there'll be issues because you'll simply have a PO box. And I think taking a step back, it's very important, certainly when doing business in Oman, that you don't only get the PO box address, which is the normal postal services, but you also have a full physical location address, which is what a courier company would want. Just answering the wider question from the Oman perspective, what the Omani arbitration law written in '97 says is about delivery by hand or delivery by courier, or it doesn't actually talk about service via email. But I think given the current climate, especially, and the times we live in, it would be deemed to be valid service, so long as you prove that you've also attempted other methods such as courier service. So that's all I wanted to say from the Oman perspective.
I think from a Kuwait perspective, and it goes to what Thomas said, and following up on James in terms of each jurisdiction, you kind of got to look at the dynamics of that jurisdiction very closely. For example, in Kuwait, there's a process of service that's done through all official documentation. And it's one way to kind of guarantee that a party cannot claim later on that they were not served with something. So obviously, well, not obviously, because you may not know how arbitration works in Kuwait, but there's no separate Kuwait arbitration law that would dictate service. You would go to the procedural rules of the tribunal and go through that, and it'll be followed. However, if you want to put that stamp of security on it, you would go through the process service through the Ministry of Justice, which you can deliver things. It's not like, it's similar to like serving on a litigation case, but they serve any formal document. It's a process that goes through it, but it's extremely important because when it comes to enforcement, let's say you get a judgment in KCAB outside and you want to bring it and enforce it into Kuwait, one of the possible challenges to that arbitration award will be whether or not there was proper service, if they were contacted correctly, and they're going to look at the procedural aspects of service and representation in that arbitration. So we always say, if possible, let's serve it through this means, because then that'll kind of close the gaps when it comes to arguing that they weren't served or waiting service.
Yes, just I will add very briefly about Qatar. Obviously, there is a difference between institutional and ad hoc arbitration. if this is institutional, in general, the rules applicable to serving the document of the institution shall apply, because Qatari law is silent about this. There is no particular rules for serving arbitration proceedings. If this is ad hoc, then we have a court judgment appointing the arbitrator, then the way the arbitrator appointed by the court will decide the best way to serving, and most probably they will use the service method set out in the procedures law. So this is in general the position in Qatar.
Okay, so second gentleman, just my second question is that regarding just hybrid arbitration clause or wrongful arbitration clause. In case of Korea, back to 2004, there was a hot issue about called optional arbitration clause, such as a litigation or arbitration. In that case, the Korean Supreme Court finally judged that if there is no further agreement to clearly to resolve their dispute by arbitration, in case of optional arbitration clause, if one party still insists the litigation should be applied, then the validity of arbitration agreement, it is not recognized. But including this hybrid arbitration clause, such as non-existing arbitration clause, such as KCAB, but however, KIAC, Korea International Arbitration Center. In case of Korea, on the opposite to the verdict of optional clause by Supreme Court of Korea, Korean court is quite friendly to arbitration clause in the case of typo, in case of typo clause. So because the KCAB is the only arbitral institution provided commercial arbitration resolution service in Korea. But how about just what about just MENA reason?
I mean, I'm happy to kick off for Kuwait. Great question. And this comes up all the time in terms of arbitral clauses that are in Kuwait documents, especially where you're looking to arbitrate outside. It's critical. So an optional arbitration clause is going to be looked at very closely by the Kuwait courts. And usually the dynamic here is you have a Kuwait party that wants to go to Kuwait courts, regardless of an arbitration provision. You have a foreign party that wants to take advantage of the arbitration clause. Where it's optional, you risk that the Kuwait courts will say it's not a binding arbitration clause, it's an optional clause, therefore they'll look to the regular jurisdictional analysis of so was the contract performed in Kuwait? Is there a party in Kuwait? And they'll look through that, and they could usurp jurisdiction of that matter where there's an optional clause. So what we always advise from a Kuwait law perspective is make sure it's clear, make sure it's not optional, and that the proper property authority and capacity enter these clauses was obtained by the Kuwait.
Yes, I would say the same would be in Qatar. It's definitely it's not recommended to insert in the contract that either party has option whether to go to arbitration or litigation, because, and especially when you give one party this right. So this will be a little bit uncertain whether there is arbitration clause or not, and whether because you know that under the civil code in general, the intention will be looked at. What was the intention of the party? Did they want to deviate from the default jurisdiction of Qatari court to go to arbitration or not? So in the fact that you leave this option open, so I can go here or there, most probably it hasn't been tested before Qatari court yet, but I would say, knowing the precedent, I would say that the Qatari court would most probably accept the jurisdiction and hear the case and consider that the intention of the party on the arbitration clause is not clear, and hence I will keep the case within the court. Thank you.
If I can just add from the Oman perspective, it's almost mirrors the Qatari situation. An arbitration clause has to be devoid of, it's got to be free of any ambiguity whatsoever. And I think in the circumstances discussed, obviously it will always turn on the exact wording of the clause in question, but the principle of it, having that option, makes it look like the parties haven't made a definite decision, and almost certainly the Omani courts would take jurisdiction themselves. Yeah.
And I think it's broadly a similar analysis here in the UAE. If there is any ambiguity in the arbitration agreement, and if there's an option to litigate or arbitrate, again, it's going to depend on the specific wording of the clause, but broadly speaking, you are running a significant risk that the local courts will assert jurisdiction over the matter.
Okay, I see. So as well that just you just look at the list of participants, we can just see many of names we already familiar from just Korea. So my final question goes to Jiwon. Definitely just other further speakers can answer as well. From the perspective of Korean businessmen, except or other than construction and energy, is there any specific trend of dispute in the MENA region? Or just that should be just aware from the perspective of Korean businessmen? What is the most frequent one, and how to resolve, how to be aware? Jiwon, could you turn on your voice?
Yes, this is a very broad question, and may vary by jurisdiction. But if I have to categorize them, I would say, as Philip mentioned for his KCAB case, the most frequent type of dispute is about the termination of agency arrangement. Most of Middle East countries has its own agency distributorship laws, and it gives actually a statutory protection to the local agent distributor in certain cases, even if the governing laws and dispute resolution clauses, they say different. For example, in terms of registered agent relationship in the UAE, it automatically applies UAE law only, regardless of different contract wordings on governing law and dispute resolution. And the other one, like for example, for the non-payment issues, before our client initiate the proceeding, I always recommend the client to do the thorough due diligence on the financial status of counterparty, because it is actually not really easy to actually collect the money in these countries, as most of their assets may locate somewhere else. And even if you receive a proper judgment in favor of our client. So I always say it is always very important to get a proper advice from local experts, not in general, but very specialized in each jurisdiction in the Middle East and African states.
So Philip, do you have any further comment?
No, I agree completely with what Juan said, and it's what we found in the case that we were involved in. We were actually on the local distributor side of that one. We usually find ourselves on the foreign principal side, but that one was actually local side. But there was a proper clause, arbitration, and it went to KCAB. But when it comes to agency distribution, we find that's probably the #1 created issue. So we have a lot of foreign principals that are doing business in Kuwait through an agent or a distributor, and those things are being challenged at the end. And there's been a termination of the relationship, it's expired, or there's been, it has not been amicable, so there's going to be a lawsuit. And the key is here, the local agents and distributors, and I'm not speaking for Oman, Qatar, UAE, but I'm sure it's similar, want to get into the local courts. Because like Joanne said, there's statutory protections for these agents and distributors, especially in Kuwait. And you want to get away from those things. And the best way to do that is have a proper arbitration clause that's clear, not an option. And then that this thing, because we've been very successful before the Kuwait courts in getting cases dismissed for lack of jurisdiction due to arbitration clauses, where it's been clear. So if that's the case, then you can apply a foreign law. If you're in an arbitration, a foreign arbitration, apply a foreign law that doesn't have these type of protections and really protect yourself. At least particularly for Kuwait.
Okay, so if you don't have any further comment from the speakers, it's just we are just running out of time, so I'm gonna just conclude this wonderful webinar now. Well, actually, just KCAB International had make a rule. Well, very frequently just go to Dubai for promoting or provide just a more informative one to Korean clients working in MENA region and the foreign clients. But however, as well that due to COVID-19, we cannot just go anywhere, just only stay in my home or office. But however, thanks to just medical cure and such as vaccine, just I hope at least maybe just third quarter or fourth quarter next year, just we can just reboot our just professional activity together with Tamimi in Dubai or Qatar or Oman or Kuwait. Until just we seeing each other in person, please stay well and stay safe. Thank you. Thank you very much for participating.
Thank you.
Thank you. Thank you for having us.
Thank you.